Hello viewers, in the last session we discussed in lesson 1 the company law administration in India. In this lesson 2 we are going to discuss the procedure of incorporation of a company. The objectives of the lesson are to identify the stages in the formation of a company, to appreciate the role of a promoter in incorporation of a company, know the fundamental documents required for incorporation of a company. The reader should know the formalities required for commencement of business. What is the nature and definition of a company? A company in common parlance means a group of persons associated together for the attainment of a common end, social or economic. It has no strictly technical legal meaning. This was observed in Stanley Re 1906, 1 Chancery 131. The law relating to companies in India is contained in the Companies Act 2013. A company in broad sense means an association of individuals formed for some common purpose. This was observed in Smith v. Anderson, 1880, Chancery Division, page 247. Lord Justice Lindley defines a company as an association of many persons who contribute money or money's worth to a common stock and employ it in some common trade or business, and who share the profit or loss arising therefrom. The persons who contributed the money to the common stock are called members of the company. The total money invested in the project is called the capital of the company. The proportion of capital to which each member is entitled is his share. The term promoter has not been defined in the Companies Act 1956. It indicates a person who originates the scheme for the formation of a company, has the memorandum and articles prepared, executed and registered, and finds the first directors, settles the terms of preliminary contracts and prospectus if any, and makes arrangement for advertising and circulating the prospectus and placing the capital, is emphatically a promoter in the fullest sense. This was observed by Palmer, Company Precedents, 17th edition, page 24. Lord Justice Bowen observed that the word promoter is not a term of law but a term of business, usefully summing up in a single word a number of business operations familiar to the commercial world by which a company is generally brought into existence. In USA, the Securities Exchange Commission Rule 405A defines the term promoter as a person who, acting alone or in conjunction with other persons, directly or indirectly takes the initiative in founding or organizing a business enterprise. The stage of conceiving an idea and its working up is termed as promotion. The person involved in this task is called promoter. A promoter is a person who brings about the incorporation and organization of a corporation. According to section 2 subsection 69 of the Companies Act 2013, the term promoter is defined as a person who has been named as such in the prospectus or is identified by the company in the annual return referred to in section 92, who has control over the affairs of the company directly or indirectly, whether as a shareholder, director or otherwise, in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act. The proviso excluded persons acting in a professional capacity. For example, a solicitor who prepares the necessary documents for incorporation of a company is not a promoter. Likewise, an accountant or valuer who helps the promotion in his professional capacity is not a promoter. Ministry of Corporate Affairs, that is called MCA, has launched a program for managing the work relating to filing of documents etc. with ROC and getting approvals from Ministry of Corporate Affairs. The physical filing of all forms has been discontinued and converted into electronic filing. The promoter has to file an application for registration of a company before the ROC of the state where the address of the registered office of the company is situated. A promoter has to make an application in a prescribed form and manner and on payment of prescribed fee for reserving name for the proposed company. The promoter has to file the following documents duly stamped together with the necessary fee with the ROC. This is discussed in section 7 of the Companies Act. The documents are the Memorandum of Association of a Company and the Articles of Association of a Company duly signed by 2 persons in case of a private company and 7 persons in case of a public company. The agreement, if any, which the company proposes to enter into with any individual for appointment as its managing director or whole-time director or manager. A declaration that all the requirements of the Act have been complied with. The declaration should be signed by an advocate or any proposed director, manager or secretary of the company or by a secretary or cost accountant or a chartered accountant who is in whole-time practice in India. The documents have to be in print or computer printing but not Xerox. Each subscriber to the memorandum and in case of a person is named as first director in the company have to file an affidavit stating that he has not been convicted of any offence in connection with the promotion or management of a company during the preceding 5 years. And the documents filed for registration contained correct and complete information and the true to the best of his knowledge and belief. The promoter has to give the address for the correspondence till the company's registered office is established. Each subscriber has to give his surname, residential address, nationality and such other particulars with proof of identity as may be prescribed. The company has to maintain and preserve at its registered office copies of all the documents and information as originally filed till its dissolution under the Act. If any person furnishes any false particulars for any material information of which he was aware, he is to be liable for action under section 447 of the Act. In such cases, an application can also be made to the tribunal, which may, according to its satisfaction, pass any of the following orders. A. Pass orders for regulation of the management of the company. B. Direct the liability of the members is to be unlimited. C. Direct removal of company's name from the register of companies. D. Pass such orders as it may deem fit. If the registrar finds the documents to be satisfactory, he registers them and enters the name of the company in the register of companies and issues a certificate called Certificate of Incorporation. The Certificate of Incorporation brings the company into existence as a legal person. From the date of issue of Certificate of Incorporation, the company is born. Certificate of Incorporation is conclusive evidence. A certificate of incorporation issued by the Registrar of Companies in respect of a company is conclusive evidence that all the requirements of the Companies Act have been complied with in respect of incorporation. The reason for this rule was explained by Lord Cranes in Repeal's case, decided in 1867, Law Reports 2 Chancery 674. when once the memorandum is registered and the company holds out to the world as a company undertaking business, willing to receive shareholders and ready to contract engagements, then it would be the most disastrous consequences if after all that has been done, any person was allowed to go back and enter into examination of the circumstances attending the original registration and the regularity of the execution of the documents. In Jubilee Cotton Mills Limited versus Lewis, decided in 1924, AC 958, on 6th January, the necessary documents were filed with the Registrar of Companies. On 8th January, the Registrar of Companies issued the certificate of incorporation, but ROC dated its 6th January instead of 8th January. The company allotted some shares on 6th January before the certificate of incorporation was issued. The question arose whether the allotment was valid. It was held that the certificate of incorporation issued was conclusive evidence of all it contains. Therefore, the allotment was valid. Once the certificate is issued, the company becomes an independent legal entity. It requires perpetual succession. The property of the company is the property of the company only, but not the property of the shareholders. In Musa Ghulam Arif versus Ibrahim Ghulam Arif, for incorporation of a public company where minimum 7 members are required, 2 adult members signed the memorandum of association and 1 guardian making a separate signature for each of the 5 members. Even though it was signed by 2 competent persons and 1 adult on behalf of 5 minors, the ROC issued the certificate of incorporation. It was contended that the certificate of incorporation should be declared void. Lord Macnaghten said, "Their lordships will assume that the conditions of registration prescribed by the Indian Companies Act were not duly complied with, that there were not 7 subscribers to the memorandum, and that the ROC ought not to have granted the certificate, but the certificate is conclusive for all practical purposes." Thus, the position was firmly established by Chandra Reddy Chief Justice in TV Krishna versus Andhra Prabha Private Limited. The Express Newspapers Private Limited were the leading publishers of newspapers and weeklies. The company has to adopt certain recommendations of the wage board for the improvement in the terms of service and salaries of working journalists. Thereupon, the Express Newspapers sold its undertaking to a new company known as Andhra Prabha Private Limited. It was contended that the new company was formed with a view to avoid the new responsibility prescribed by the wage board, and therefore the registration of the company should be declared void. It was held that even in such cases, the certificate of incorporation was valid and only remedy available is to file a petition for winding up. Commencement of business. This was discussed in section 11 of the Companies Act 2013. To commence the business of a company having share capital, the company has to satisfy the following requirements. A declaration has to be filed by a director with the Registrar of Companies in a prescribed form and manner, and verification that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him. B. The company has filed with the Registrar of Companies a verification of its registered office as required by section 12 subsection 2 of the Act. In case any company violates these conditions, it is liable to pay penalty extending up to 5,000, and for every officer who is in default up to 1,000 for every continuous day of default. Within 180 days of incorporation, in case the company fails to file such declarations and the Registrar of Companies has reasonable cause to believe that the company is not carrying on any business, he may initiate action for removing the name of the company from the register of companies. The law of persons. According to Salmon, a person is any being whom the law regards as capable of rights or duties. In law, there may be men who are not persons. Thus, for example, formerly slaves were destitute of legal personality in a system which regarded them as incapable of rights or liabilities. Persons are of two kinds, natural and legal. A natural person is a being to whom the law attributes personality in accordance with reality and truth. Natural persons are human beings and consequently persons in fact as well as in law. A legal person is any subject matter other than a human being to which the law attributes personality. They are persons in law but not in fact. Legal persons are also described as fictitious, juristic or artificial persons. Kinds of legal persons. A. Corporations. A corporation is a group or series of persons which by a legal fiction is regarded and treated as a person. Corporations are of two kinds, corporation aggregate, 2. Corporation sole. Corporation aggregate, it is a group of coexisting persons. Corporations aggregate have several members at a time. Example is a registered company. 2. Corporation sole. A corporation sole consists of an incorporated series of successive persons. Corporation sole has only one member at a time. Examples are President of India, Chief Justice of India and the Prime Minister of India. The term person is derived from the Latin word persona and originally conveyed the meaning of a human being. Corporate aggregate is of two kinds. They are trading corporations and non-trading corporations. Examples for trading corporation is Tata Iron and Steel Company and examples for non-trading corporations are universities, clubs, municipalities. The term company is derived from a Latin term called companis. Com means with are together, panis means bread. Companis means bread sharer or breadwinner. Next, theories of corporate personality. There are 16 theories of corporate personality, out of which the following 5 theories have gained currency. They are fiction theory. This theory, which found favor with Salmon and Holland, holds that a personality is attached to groups and institutions by a pure legal fiction, and this personality is distinct from the personality of the individual beings. According to Salmon, a corporation is nothing more than the outcome of metaphor and fiction. B. Realistic theory. This theory, expounded by Girk, holds that the group or institution has an existence beyond the aggregate of the individualities or persons forming it. A corporation has a real existence. Its personality exists not by figment of imagination but is independent of recognition by the state, for law has to take notice of it to keep pace with the realities. It has corporate will which is expressed through the acts of its servants and agents. The third theory, concession theory. This theory, expounded by Savigny, holds that the sovereign and the individuals are the only realities. All intermediaries and institutions cannot claim recognition as persons. They derive their existence from the sovereign, and as such, corporate personality arises only as a result of state acts or by concession of the sovereign. Next theory is bracket theory. According to Patchen, bracket theory, which regards the members of the corporation as the bearers of the rights and as being bound by the duties which are for convenience, refer to the corporation itself. Next theory is purpose theory. Brinz, the German jurist, has propounded the purpose theory of corporate personality. In Germany, foundations or Stiftung are treated as juristic persons. A foundation is no more than a trust for specific charitable purpose. Such trusts or foundations are not treated as persons in English law. About the foundation or Stiftung in German law, Brinz observes that the juristic person in such a case is merely the property set apart from the foundation personified for facilitating legal transactions. The next topic is liabilities of corporation. A corporation is not a natural person and has to act through its agents. The law provides that a corporation owes both civil and criminal liability for the acts done by its agents within the scope of their employment. As regards civil liability, a corporation is liable for the tortious acts of its servants or agents if the act was done within the scope and course of employment and the act was within the powers of corporation. This is the rule of vicarious liability under law of torts. With reference to contractual liability, it has been held that generally corporation contracts under a seal and the presence of the seal is an evidence of the assent of the corporation. It has been held that the relation of the corporation to its agents fall within the ordinary law of master and servant, and consequently an agent is bound to act within the scope of his authority if he wishes the act to bind the corporation. The capacity of a corporation to act may be limited by the terms of its object clause or statute. So, any attempt to perform an act beyond those powers would be ultra-wise so far as the corporation is concerned and consequently would have no legal effect. As far as criminal liability of a corporation is concerned, the old view is that corporations have no criminal liability is now not valid. Nowadays, a corporation can sue or be sued for crimes such as defamation, deceit, malice and malicious prosecution. This was observed in Citizens Life Assurance Company versus Brown, 1904, AC 423. It cannot have a guilty intention necessary for a crime, as a corporation has no mind of its own. Corporate liability is attracted due to the application of the identification doctrine. In every corporation, there are certain persons who control, manage and direct its activities, such as the directors, the officers, the company secretary. Their acts and state of mind are the company's acts, and state of mind and the company is held for them as if the company itself did those acts. The guilty mind of the persons in control is identified with that of the company. This was observed in Rex versus ICR Haulage Limited, 1944, King's Bench, page 55. Company was held liable for conspiracy to defraud because the company's managing director and other superior officers had conspired to practice fraud upon some other company. The managing director's guilty mind was identified and considered the same with that of the company, and the company held liable. In Moore versus Bresler Limited, 1944, to All England Reporter, page 515, the company was held liable for the criminal fraud of the secretary. Company is not a citizen. A company, though a legal person, it is not a citizen neither under the Indian Constitution nor under the Citizenship Act. In State Trading Corporation of India Limited versus CTO, it was held that though the State Trading Corporation is incorporated as a private company under the Companies Act and all shares were held by the President of India and two secretaries, it was not a citizen under the Indian Constitution. nationality, domicile and residence. A company incorporated in a particular country has the nationality of that country. Though unlike a natural person, it cannot change its nationality. This was observed in Cunell versus Donesmark. Ordinarily, the residence of the company is at the place where its register office is situated. In this session, we discussed the procedure of incorporation of a company, that is, the meaning of the term promoter, the fundamental documents which are required to be filed with the register of companies, and the theories of personality and kinds of persons. I hope you enjoy this session and we will meet in the next session. Thank you.